So following on from the different rules and regulations that exist, we now start to think about global information protection and what legislation and regulation applies specifically when we move outside of the UK and the European Union. So it specifically covers if we need to import, send, or process any data outside of the United Kingdom. Now, because the UK and the European Union and the European economic areas, they're all covered by GDPR. So moving data and processing data, within the European Union, within the member states of the European Union or the EEA, that's just really not that big a deal because we're all covered by the same very stringent data protection legislation. It becomes a problem if we want to do something with our data and we're now dealing with countries that are outside of these European countries because, well, their laws may not exist, or they may have laws that exist but aren't as stringent as our laws, or we may have to think about putting something else in place so that we can still do business with these companies, these organizations, even though they exist. Their business exists outside of the European Union. So we go to the ICO, the Information Commissioner, to see what do we do if we have to send information or receive information or process information in countries that don't have any Data Protection Act or GDPR, any laws in place. And this whole section here deals with international data transfers. And it gives you examples of what these things might look like. So if we scroll down, we can see there are some changes, okay? And this section relates specifically to moving data outside of the UK. So it tells us quite clearly the UK version of the GDPR applies to the processing of personal data you are transferring. It does not apply to the importer of data because they're located in a country outside of the UK, such as the EU or somewhere else. And you, the sender of the data, and the receiver of the data are separate organizations. So if all this applies to us, then we need to start to think about, well, what does that mean for us, okay? If your restricted transfer is not within the European Union, then you will need to have thought about how you can still comply with the stringent legislation that is the GDPR. So we've got these things called adequacy decisions and appropriate safeguards. So this is what the Information Commissioner tells us. You can still make these restricted transfers as long as there are adequacy regulations that confirm that the country has an adequate data protection regime. In other words, if they've got a version of the Data Protection Act that is as good as the one we have, then that shouldn't be a problem because they're considered to be adequate. So the next bullet point tells us Japan are one of these countries that are considered to be a good country with a good GDPR equivalent. If we want to send information to the United States, there is an adequacy decision surrounding this thing called Privacy Shield, which is a specific arrangement between the European Union and the United States. And arrangements have been made to ensure that data transferred to and from the UK to the United States complies with the stringent legal legislation that we have in this country. So we should be okay then dealing with the United States. And if there is no adequacy decision made, in other words, if America's rules change, or if we're dealing with a country outside of Europe, outside of the UK, and there isn't a general data protection regulation in that country, they don't have any laws that are as good as ours, or they don't have any laws at all, then there are certain safeguards that have to be put in place. And generally these are standard contracts. So you'll have some kind of standard contract, legally binding contract with that country, and these are EC approved, and they cover all the legal aspects of transfers of data in and out of these countries that brings them in line with the same kind of standards that we have in this country. So it tells us here that there are various things that we can do. Even if these countries don't have their own regulations, we may still be able to deal with them, but there are just certain things we have to put in place, legally binding contracts and binding corporate rules and so on first, okay? Now, there is an exception. If there's no adequacy decision, in other words, if they're not considered adequate, their laws aren't considered adequate, and there are no appropriate safeguards either, so you can't put a contract in place, then you still may be able to make a data transfer if it comes under one of these particular exceptions, okay? And they're all listed and explained here on this page from the Information Commissioner. So one of the exceptions, for example, is you might need to make a restricted transfer for important reasons of public interest, but there is no particular law, so you should consider it an appropriate safeguard. It can only be used in specific situations. You must be able to satisfy yourself that the transfer is necessary and it's for the reason of public interest. Okay, so there are some exceptions to the rules, but generally there has to be some legal agreement between you and the country you're dealing with, the business that you're dealing with in that country, to make sure that they are complying with those same laws or an equivalent of those laws.